get started. The format for today, we're going to do a quick intro about Norm and his law firm, kind of where they are, what they service, and then we'll get into some of the specifics of negotiating a purchase and sale agreement, both from a buyer and seller perspective. It's important for us to cover both. So we'll dive into some of that. And then we'll leave the last 10 or so minutes open for Q&A. So I will do my best, Norm, to moderate the chat box and the Q&A box. For those of you joining us, just feel free to use either the chat box or the Q&A box. And like I said, I will moderate those and we'll save some of those questions for the end. Norm and I will go through some of the general content that'll probably be applicable to everyone. And we'll do an intro, we'll go through our content, and then probably in the next 25 minutes or so, we'll open it up for questions, and then we'll wrap things up as we normally do. With that being said, Norm, I'm going to turn it over to you. Please give us an intro about kind of who you are and what your law firm focuses on.
Thank you, Danny. We are a property solutions law firm focusing almost exclusively on multifamily communities, their owners, investors, and property managers. We are in North Carolina, South Carolina, and Georgia. We go to other states in the area and we'll affiliate with local title council and things to assist there as well. We regularly close multifamily transactions, buying, selling, refinancing from a few $1 million to 60, 80, $100 million transactions. We also support multifamily management firms. So most all the large ones in North and South Carolina, we work with them. A good portion of the mid-sized ones. I believe we're somewhere around 1,400 or 1,500 communities we support right now, just on day-to-day issues and litigation, from tenant lawsuits to how do I comply with all these new regulations coming out from the CDC or the various executive orders from the states, what's going on in the courts, things like that. And I myself am general counsel to the North Carolina Apartment Association and also the Raleigh-Durham Area Triangle Apartment Association. And our attorneys, such as myself, are involved on the state, national, and local level. I'm a NA, National Apartment Association PAC trustee. We're allocating funds to try and get the legislators to do some good things for us all. Just yesterday I had a meeting about that. So we are very involved and kind of live the multifamily investment life.
Yeah. So just to kind of recap what I heard for the listeners, basically you personally and the law firm are very well connected to both the ownership side of things within the multifamily space, as well as the association side of things, helping out with, I don't know if the right word is lobbying or working with the different branches of government to make sure that owners' interests are accounted for in the decision-making process. Is that fair to say?
Yes, exactly. We're very involved with that, and also on the management side of it all. We assist the management companies in making sure that the properties are compliant and addressing legal issues that they come up with.
Yeah, the other important thing I heard you say is I think you guys represent 1,500 to like 2,000 communities. And when I do that math, if I'm just thinking of like the average community being 100 or 200 units, you guys are working with, from a legal perspective, several 100,000 apartment units specifically.
Yes, sir.
Yeah.
Yes, sir. We see all different types of things and see them over and over again.
Absolutely. Now, one important distinction, I do want to shift the focus of the conversation specifically to the purchase and sale negotiating side of things. But one important distinction that I do want to make is our group, PassiveInvesting.com, works very closely with Norm and his team on the transactions that we do. So we have a business relationship with Norm and have been very pleased with all of the closing and kind of pre-closing, closing, and post-closing work that his firm does with us. And also, our property management company engages the Brownlee, Whitlow, and Praet team for all of the property legal matters regarding residence or eviction process. And again, one of the key things that Norm stated early on is that his firm works very closely with NAA, National Apartment Association, and some of the other specific groups in the Carolinas. But the NAA group is a national group, all focused on the landlord-tenant laws and different pieces and procedures to that. Norm, any closing thoughts or comments to add from a high level about your group, what y'all focus on, or did we kind of cover things pretty well?
I think we covered things very well. We can move on to what people really would like to hear about now.
Yeah. So I think when I think about negotiating a purchase and sale agreement, I guess let's tackle it from a buyer perspective, right? Because most of the folks joining us today are thinking about buying a multifamily property. And so one of the questions that I frequently hear is, when do I engage an attorney when I'm thinking of negotiating a purchase and sale agreement? So let's say, Norm, I get an email from a broker. There's a new deal going out. I go and tour the deal. I underwrite the deal. I like the asset itself, and I want to submit an offer. When do I start to engage with you and your team to negotiate a purchase and sale agreement? Do I do it before the contract, or do I wait until the deal is verbally awarded to me, and then I come to you and say, hey, I've got this property under contract. Here's the purchase and sale agreement. Can you help review it? What's that process like?
Well, ideally, if you would engage us prior to even getting an LOI, so we set up a relationship and everything, and we can help you with the LOI. They're generally non-binding, so you usually won't get too far afield with those, but it's not a bad thing to have us review the LOI. And then certainly prior to entering into a contract, we have people come to us with contracts in hand, and sometimes they're just on state realtors forums and things, and there's just a lot of issues that they don't address, or even worse, if they're not on a state realtors forum, they've been put together by the seller's attorney, and they've really kind of cornered the buyer in lots of different areas that they might not want to be quoted, and they've sort of hamstrung their rights. And there's a whole lot of terms in there that are negotiated in every deal. And almost these contracts are 20, 30, 40 pages long, but almost every provision has something that gets negotiated in it. And depending on which side you're sitting on, buyer or seller, it can be better or worse for you.
Yeah. Now, from a buyer perspective, without getting into the specifics, right, because every multifamily property is different. Every contract is going to be a little bit different. What are like 2 or 3 things that a buyer should be aware of as something critical to look for in a purchase and sale agreement?
Okay. Forgot one thing that we should have done at the outset real quick. The disclaimer: this isn't legal advice. We're not giving legal advice to the attendees, nor is Passive Investment Multifamily Investor Nation anybody offering legal advice. This is purely for educational purposes. Sorry, just had to get that in there before we got any further. So what are a few things that they should look for? Well, among the more highly negotiated provisions now are earnest money. How much is it? Who's holding it? Very important. When does it become non-refundable? When does it go hard? And if it goes hard, what are the exceptions to that? So how much? That's, purely negotiated, usually 1 to 5%. Who holds it? Ideally, you have the escrow and a separate escrow agent holding it, because if there's a dispute, the party holding the money has a little bit more leverage, and if it's with a third party, it makes it a little bit easier to negotiate things. And as opposed to when does it go hard? It used to be that you'd go through due diligence and then the earnest money would go hard with the hotter real estate market for multifamily and things leading towards the seller side in negotiations. Some portion usually goes hard right away. As sometimes it's all the earnest money, sometimes it's a quarter or half, and then you give the other 2/3 or 3/4 or half after due diligence is up, and then that becomes hard. And then really important, what are the carve-outs to getting your money back? If you have money that goes hard immediately, you're doing that as a buyer based on the representations that have been made regarding the financials. So you want to have a carve-out that if any of those financials prove to be inaccurate at the time they were given, you don't want people just making up numbers and giving them to you when you gave them hard money, essentially. So that's a very important part. Then you want to have representations regarding title, that the title's clear, that they're going to be able to close. Environmentals, whether that it's not going to cost you a substantial amount of money due to some environmental issues. It would be great to get engineering in there. Usually engineering, the sellers will strike out. But if you can get engineering such as no repairs over X dollars or something, or the engineering doesn't find that you're going to need to do more than $100,000 or $50,000 or some number based on that. And then always in case of seller default. If the seller doesn't do something that they're supposed to do, you get your money back. And we also try it into, and we're usually successful, that all sellers' reps and warranties in the contract are true and correct. If any of them become untrue when given, then you should be able to get your money back if they were incorrect when they were initially given. Not saying that financials don't change over the contract and things like that, but just that nothing was specifically misrepresented at the time it was given.
Absolutely.
Well, you can also key into, we find people more these days with the CDC moratoriums and things, keying into guaranteed occupancy or gross income rates for the property. You want to make sure your lender's underwriting this at a certain occupancy number or dollar value. And as a buyer, you'd like to put that in the contract and make sure that you can get most of or all your money back if anything falls below that.
Yeah, absolutely. And I think, just keeping in mind for, everyone listening, it's important to understand the level of sophistication of buyer and seller when we're talking about this. So I'm going to kind of caveat that there's a couple different levels of transaction. And the first level, I would say, if you're buying a deal that's less than $5 million, you may have more control or ability to negotiate between the seller and the buyer and the broker and try to get some of these terms knocked out prior to a PSA, because it's going to be a little less sophisticated than if you're buying a $50 million deal from a massive institutional seller. And so that is a very different conversation. And, institutional sellers on a $50 million deal are pretty rigid in terms of what specific terms they will have. And if they don't have this specific term, they may not sell to you at all. And they're just going to move on because they need these terms to protect their institutional group. And so the 5 million or less is probably a little bit more negotiable and transactional. And if you don't have a broker at all, then it's going to be really up to you as the buyer or you as the seller, the buyer and the seller, to really negotiate terms. And so you can kind of be creative with whatever terms you want. Norm really listed a lot of different terms that are going to be in that PSA provision. And so if it's less than 5 million, you probably have a little bit more say in what goes on. If it is an off-market deal, again, you probably have more say. And I'll say if it's above that $5 million mark, and there's a broker involved in the transaction, you should be able to get a good idea from the broker of what the typical LOI terms are. If you haven't bought a deal before, having those kind of generic LOI terms set out, like the price, as Norm mentioned, how earnest money and hard money will be treated. Those are things you want to work out prior to, which is why you would work with Norm prior to, or someone from his team prior to submitting that LOI or that offer, so you can understand and really present yourself as a professional buyer and seller. So one of the critical terms in there, Norm, that we talked about, hard money, right? It's a huge conversation. And for this one, and kind of going forward, let's talk about a larger deal that's a little bit more traditional with a seller, a broker, and a buyer, and it's a $20 million deal. When someone is negotiating what hard money is, I think some of the contingencies from a buyer perspective that we talked about, a clean environmental report would be great to have in your PSA as a buyer, clean title, a clean zoning and survey, and obviously seller is representing factual financial information. They're not committing fraud or defrauding in any way. Is there a fifth item that would be an important one from like a hard money clawback for a buyer?
I like to tie into all the reps and warranties, and that's a whole further, I don't know whether we're going to get into that, but tie in all the reps and warranties being true and accurate, not just the reps and warranties regarding the financials. And I also saw a question while we were talking. I'd mentioned an LOI, and as had you, that's a letter of intent that sometimes somebody was unsure what that was. That's a letter of intent that's sometimes exchanged often exchanged prior to going under contract. So the parties just sort of have a meeting of minds that you're not locked into a contract, but you basically come to a price and maybe a few other terms, such as the due diligence period, inspection period, and closing period, and things like that. There's only a handful of terms there. Also, when you were talking about the less sophisticated deals, smaller amounts, one thing you really want to get in those deals is bank statements and things. From the more sophisticated, hopefully you want to ask for bank statements, but hopefully you can rely on their income statements and things like that if it's been professionally managed and everything. But the smaller deals that are less professionally run, the numbers can be fudged a little bit more and not as clear. And so you want to make sure you can back up any representation that you've received on those as well.
Yeah, perfect. Okay, now let's say from a buyer perspective again, we've talked to you, we've got kind of our generic LOI terms, price, due diligence, the closing timeline, how hard money is going to work. We submit the offer's accepted. What is the typical process for reviewing and getting a PSA signed? Is it a lengthy process? Is it pretty quick? How are these conversations taking place? I know it varies deal to deal, but just on kind of a very high level, like what should a buyer expect to happen?
Usually in your letter of intent, your LOI, you want to include who's going to prepare the contract, so you know when that's going to be done or who's going to do it, and when it needs to be drafted by and sent to the other side. It really varies. Often on a lot of these bigger deals, it's coming from the seller's attorney, because they have to satisfy various requirements and everything. It can be by the buyer's attorneys, and we do many contracts on behalf of buyers as well. But more often than not, it's coming from the seller's attorney. And honestly, on the bigger deals, I mean, there's a fair amount of things we negotiate, but they're usually fairly fair contracts compared to some of the smaller deals where you see things that are a lot more one-sided, that will be things that most educated or experienced buyers would never agree to, that are coming from the seller's attorney just because they're trying to throw in anything they can. On the larger deals, usually they're not wasting your time with throwaway terms that buyers will never agree to. It's just the points around the edges, on the margins, basically, and making things as friendly to one side or the other as you can negotiate.
Yeah. And again, for those of you joining us, use the Q&A box, use the chat box. We're going to go to questions in maybe about 5 minutes, but I want to make sure that you all are getting your specific information so we can kind of cover some of those really important topics to all of you. One of the things that recently came up quite frequently that I've heard a lot about is the force majeure clause after kind of COVID broke. I've been hearing quite a lot about that. And Norm, would you just tell us what that is? And are you finding contracts to be signed with a force majeure clause?
Now, I would say for the most part, many contracts had a force majeure clause. It's just what's within that force majeure clause. Force majeure is if there's sort of a major disaster of some form or other, whether it's a civil war, a war. Now we try and include pandemic language and health emergencies and things like that in there as well, whether it was a fire or a tornado went through, something like that. That's still a negotiated term. The sellers we're not still finding are giving all that much, especially if they're saying at this point, you know what the landscape is right now. We can't control it. So we don't want to let you out. You offer what you're going to offer and we'll go from there. But it is something that's negotiated a lot more. And I believe I was on the phone with you right around this time last year when we were negotiating a contract and trying to really start paying attention for the first time. I remember I was in Washington, D.C. for a national legislative conference at that point and working from my hotel room as I often do with those things. And I had a couple contracts that were properties that were going under contract and we were trying to figure out what it all meant at that point and really paying attention for the first time. We really haven't had too many major events, certainly in the past couple of decades, that have really changed contracts like the pandemic has and have done so much, made so much change within the property's financials and things as quickly as they were. Also, in the beginning, people weren't going out to properties for inspections, and the timelines were all getting pushed back in the very beginning. Things have normalized, and so we try and negotiate those terms on the buyer's behalf as much as we can, and also in those. So the force majeure also might take the form of allowing more time to do inspections, also guaranteeing, as I said in the beginning, guaranteed income or guaranteed occupancy and things during that time. Right now, we're finding with all the eviction moratoriums, guaranteed income is a whole lot more important than guaranteed occupancy. Because if you have residents in the units that have not paid for 7 months, that's not really helping you out all that much.
Right.
So guaranteed income is more important. So either sometimes you're allowed, you can tie those into the force majeure. Sometimes you just tie them into reps and warranties or sellers' obligations prior to closing to maintain that are conditions precedent to closing, things that have to be satisfied prior to closing, such as maintaining property at a certain level of income. We also have one under contract now for one of our other clients where they keyed the monthly income to the purchase price. So it doesn't get canceled if it falls below a certain amount, but the amount below it is below that monthly income is keyed to the purchase price percentage-wise. So the buyer gets a percentage reduction based on a reduction in the monthly income.
And is that a large size multifamily property? Is that more on the smaller size?
I think that's a $20 million closing.
Okay. So, I think the lesson here is just that, number one, every deal is different. Number 1A is that we're not, again, providing any legal advice or recommendations. We're just speaking, about educational information. Number 2 is that you can really work together with the seller, with the attorney, with the broker, with your attorney, to negotiate and iron out these terms. I think at the end of the day, the entire goal, if you're getting to the point of putting together a purchase and sale agreement, is to ultimately close on the property. And so I think both sides should be willing to work together on it. But again, every deal is different. Every buyer and seller are a little bit different. Norm, when you're working with a client, either on the buy side or the sell side, who is the final decision maker for terms in the PSA? Is it you, or is it the buyer or the seller, the client?
It's absolutely the client. We just give our perspective, and based on our experience and going under contract lots of times, but we really don't run numbers or anything. We don't underwrite properties. We just negotiate the terms. So with a lot of law, a lot of things are less or more risky, less or more benefited, but it's ultimately a business decision for the client, what weight they put in various things. And I mean, if you're getting a better deal, you might be willing to give a little bit more, but if the numbers are tighter, you might not have as much room to give on the buyer side or the seller side, depending on how it's coming from. So it's really a business decision. We give our perspective and our counsel, but it's the client's decision.
Yeah, that's just one important piece of information for everyone listening. Ultimately, whether you're a buyer or a seller, it's your responsibility to make sure that the contract meets your expectation or what you're comfortable with from a business perspective. First and foremost, you as the buyer or the seller must read every word in the contract, every word in the LOI. You can't rely on the attorney to be the decision maker, right? As Norm said, you as the client, you are the final decision maker, and it's ultimately your responsibility to abide by the terms of the agreement. And so you have to be comfortable with it. You have to be knowledgeable with it. And so the other important thing I want to state is, if you have never bought or sold a property before, you should have a mentor or someone to help guide you through the process so you can understand what you're looking at or what you're reading from a purchase and sale agreement. You need to be knowledgeable when negotiating. Norm and his team certainly can explain some of the legal words or phrases, but ultimately you as the owner, operator, buyer, seller have to be knowledgeable of what you're trying to achieve with that deal. Norm, with that, maybe give us one or two kind of lessons learned from PSA negotiations in the past, and either something to look out for or be prepared for, either as a seller or a buyer. Just give us 1 to 2 here, and then I'm going to go ahead and start to queue us up for some of the questions that have come in either through the chat box or the Q&A box.
Everything as you said, don't go into a contract that you're not comfortable with. Ask lots of questions if you have them, associating with a mentor or somebody who's done it before, or working with them on their own deals, or bringing somebody else a deal so you can learn is a whole lot cheap. Giving up a percentage so you can of the ownership so you can learn is a whole lot cheaper than getting into a bad deal and losing money. So I would strongly recommend that. Also, if you've got a group that you're putting together and you've got 3 or 4 of you that are working, making one person point that you primarily deal with will make everybody's life a lot easier, and your legal expenses a lot cheaper. If the law firm's getting asked questions by 4 or 5 people and they're all relatively new and they've got to go through the same explanations time and time again, it's going to take a whole lot more attorney time and could double the price on the legal side, which is a decent cost within the process and everything as you're underwriting. And
that's a great point. So if you are a syndication group, or if you have 1 or 2 or 3 partners that you work with, one person from your team should be dealing with the legal team, going through the process, and then kind of coordinating what legal feedback you have, and then go and talk with the business owners or your partners. And then one person again follows up, and that's the mode of communication to really streamline the process. Again, it's a team sport. So you got to work well with every team member that you deal with, whether they're on your staff or not. You just got to work well together. One of the questions that came in, and I'll just answer it real quick, what the kind of timeline of expectation from LOI to close is. So typically, the broker is going to have a call for offers date. Let's just say that's March 1st. They may say LOIs are due on March 1st. They may do best and final offers on March 10th, and they may award the deal to the ultimate buyer on March 11th. From that point, typically it'll take a few days for the seller to send over the PSA for your review. The typical turnaround time of getting a red line version back, so with your comments and feedback, is maybe 24 to 72 hours. Again, the broker is your means of communication. So from a buyer standpoint, you always want to be diligent in turning around revisions to a contract quickly, so you are building positive rapport with the seller group. So, maybe it takes 2 weeks to negotiate and get a PSA signed and inked. From that point, once you sign the PSA, typically your property due diligence will start. Most commonly, it's about a 30-day due diligence process, and then you have a 30-day to close process, and maybe you've negotiated a 30-day extension to close if for some reason there's a delay in getting the deal closed. So, from March 1st for a call for offers date, you're probably looking at closing a deal within 90 days or so. When money goes hard, again, that's up to you in negotiating the contract. So that's a typical process. Again, if you don't know how the process works, having that mentor, like Norm suggested, having someone part of your team, even if you're giving up a percentage of equity to them, it's going to be very helpful. You're going to avoid a lot of mistakes, which could be very expensive, as opposed to having an expert.
Can I throw something in there too, Dan?
Yeah.
When you're going back and forth, having the attorneys negotiate terms other than just basic contractual provisions, if there's any real issues throughout the closing or any major terms, it's ideally better if the buyer and seller have some rapport or they go through the agents, because the attorneys are trying to get through a whole other wall when you're going back and forth. It adds somebody else in the process, and attorneys are notoriously risk adverse. So if you're having to go through you want to negotiate certain terms of the contract, but if there's any big deal issues that come along and things along the way that you're really just trying to work and find a solution to, the sort of behind the scenes between the buyer and seller or the broker is a faster and more efficient way of getting it done. Again, attorneys want to make sure that you're covered and protected. The brokers make sure you get things done.
Absolutely.
I'd just like to add.
Couple of quick ones in here. Are you asking for financials after the LOI? No, you would want to put a clause in there of what types of financial statements that you want to have. You, of course, want to make sure that statement is in the PSA as well, that the seller will provide financial statements within 3 days of signing the contract as part of the due diligence period. Norm, here is a great question. What kind of fees can be expected on a small deal?
They really vary. And sometimes the small deals are more expensive than the larger deals because you're dealing with less sophisticated parties and you get more hiccups along the way. So I would say legal fees just on the closing are usually between $10,000 and $30,000. That's a very broad range. syndication related fees separate from that. But it really is how quickly things go, how sophisticated the purchaser is. If they've done this lots of times, the fees go down because they need less input and less assistance through the attorneys. There's less back and forth, and they also understand kind of what's going to be accepted and what's not going to be accepted, and they don't take time and cause additional costs by negotiating the various provisions that aren't going to be accepted.
Absolutely. Let's see here. For deals under $5 million, is due diligence done by the title company for title issues? Yes, the title company would research that, but as well as, your closing attorney would confirm that the title is clear as well. So that's an important distinction. At times, the title company could have an error, but Norm and his team would be there to make sure that there's clean title as well. And then the buyer...
We check that as does the lender's attorney. The lender's attorney goes there. Usually, especially the larger deals. On smaller deals, the lender may not have an attorney if you're just a few $1 million. On the larger deal, the lender always has an attorney, which is another party within the whole process. And so there's a number of people looking at the title issue. Usually titles, not, especially on the larger properties, there aren't any major title issues and things like that.
Yeah. Norm, does from your side as the attorney, do you do any due diligence of financials, leases, occupancy, anything to do with the business operations of the property?
No, generally no. With that being said, we'll look through if they have a strange lease or not a standard national lease, such as the NAA lease or something like that. We're happy to review the lease for any specific concerns, but we don't review the leases for amounts of rent or security deposits or anything like that, and we don't give any advice as to what the proper amount of rent is or not. They can go to YieldStar.
Yeah, again, so any business operations, financial statement due diligence, lease due diligence, physical inspection walkthrough, all of that is on the buyer to do. The attorney doesn't do that for you. So again, it's very important if you've never bought or sold a deal before that you have someone on the team who can help guide you through that process. You don't want to run up legal fees on things that you should be doing on your own. Let's see. What do you recommend to be educated? How could a buyer or a seller, if they're new to the syndication, what's a good way to be educated on the legal aspects of the PSA process?
Multifamily Investor Nation and their conferences and summits has various educational components. I taught one last time where it was not conversational like this, but it was more going provision by provision. Working with a mentor, as we've talked about, is probably the biggest. Finding somebody that you trust and working with them to help you through. That's one of the biggest things you can do. And also just speaking with your attorney and finding an attorney that's experienced in multifamily transactions, because again, there are a lot of very specific provisions that go into these contracts. So working with an attorney that really knows what they're doing. But again, if you're new, working with experienced people on your team, buyer side team, is really important and immeasurable value.
Yeah, podcasts, webinars, reading purchase and sale agreement documents, understanding what terms are in there, going to Google. If you don't know what this legal term means, go to Google, understand it, have kind of that basic background information. Maggie, the answer to your question, unfortunately, yes. Usually 100% of the time, the buyer will pay for the lender's attorney's fees at closing for larger multifamily syndication deals. It pains me, but it's just kind of the cost of doing business. The next question, evaluating.
You're reading, can I throw in on the LOI before you were talking about including due diligence for financials, ideally you want to append to the LOI all the due diligence items that you're going to expect to get. So you negotiate that before you get other people involved, such as the attorneys and fees start, where you might reach an impasse because you can't get something from the seller that you want, or you're not willing to give up something as a seller that the buyer is going to insist on.
Perfect. Norm, here is a question. So there's been a past sinkhole issue at a property that was repaired. What would be a clause in the PSA to protect the buyer from this sinkhole issue? Would it just be a standard inspection from a professional to sign off that the sinkhole is fully repaired, and if it ever reoccurs, that this engineering company will fix it? I'm pretty uncomfortable with having any sort of sinkhole issue on the property. I would really want to do a detailed environmental study to understand why. But I mean, what could you put in the clause to protect your buyer in the PSA? Like, if anything goes wrong, the seller is going to be responsible, or?
Well, every PSA usually has a closing point after which the seller is no longer responsible. So the seller makes their reps and warranties and things such as there's no environmental issues, and there's usually a period that's negotiated where these terms survive closing. If you don't have a specific period negotiated where any of the guarantees or anything survive closing, then everything stops when you take ownership of the property. That period is usually 30, 60, 90, 180 days. They don't usually go a full year. So you can have the seller guarantee things for a while. The other thing is, if you buy the property from the seller, who's usually a single asset entity, you give them all the money for the property. The money all goes somewhere. They don't usually just hold on to money. So going after that seller for money later on is possibly going to be, or likely going to be, a losing issue. What you can do in that case is if you really think it's an ongoing issue and you're really concerned and you can get the seller to agree, you can have a holdback in escrow for a period, such as 3 or 6 months, where there's a few $100,000 or 50, 60, a few $100,000 in escrow, depending on the amount of the purchase price. As you said, Danny, getting whoever did the repairs, having those whatever warranties they've given, having them assigned to you. A lot of them say they're not assignable. So you really have to look to see whether they're assignable when you're doing your due diligence. And they may say they're not assignable, but you may be able to go back to the vendor and they'll agree to the assignment regardless and just strike that provision from their warranty. So yeah, either the assignment of the warranty or a holdback is the best way to address it.
Yeah, again, very specific kind of question and concern about one property example. But again, that's the importance of having a good attorney to understand the complications of unique situations at a property and making sure that you're well protected. So, like I said earlier, I think every term is negotiable, and any sort of protection you feel you may need. But again, just keep in mind that it's a negotiation process. You're not going to probably win every clause that you're trying to put in there. So keep that in mind, and, have the voice of a professional to give you recommendations on, this clause may be more important than that one. Let's concede this, but make sure we get that. Andrew, question from you. Typical percentage considering giving up for a mentor on your first deal? It really depends. I would encourage you to maybe speak to some local real estate investors and see what they've done or how they've done it. Even folks from the MFIN group, because the mentor may bring more to the table than just being a phone call or a phone a friend scenario. So I can't really give you a percentage, but just talk to several people and see kind of what their level of interest would be. Online resources to find PSAs. Norm, I would think someone could Google just like real estate purchase and sale agreement and kind of get some introductory information or kind of canned purchase and sale agreement information. Is there any other like legal Google Scholar?
I mean, there's various.
Is that a thing or?
There are various legal websites. Some of them are free with advertisements and some of them are pay, where they would have that. Westlaw and LexisNexis are what attorneys use to do their legal research for cases and laws and things like that. And they usually have lots of forums, and that's a pay one. There's something Justia or something like that. law.justia.com, I think, is one where they have various forums. And sometimes you'll find these when you Google them attached to SEC filings for some sort of larger companies and things like that. And so if you just Google multifamily purchase and sale agreement or apartment purchase and sale agreement, there is a fair shot you'll find something. Again, that's just a starter point, and you don't know the quality of what you're finding compared. It really takes so you can understand the basic terms, but it takes time to really fine tune it. You want to do that so you know some of the questions. You won't have a lot of the answers looking at it. So if you're looking at it and things stick out in your mind as important to you, you certainly want to bring them up, but you'll want to rely on your, again, more experienced mentors or professional support to help you with the specific terms as well. I wouldn't just go find one off the internet and put a several $1 million contract together based on that.
Yeah, that would not be a good recommendation. Well, Norm, it's been excellent to learn about some of these critical purchase and sale agreement items, as well as some of the resources that are available. We are going to kind of wrap things up. Can you give folks just some information, the best way to get in touch with your firm? And I just want to make sure to highlight that your group can close deals and work with buyers and sellers all over the country if that's needed to be done.
Yes, we can. Outside the local 3 states, we associate with other title counsel and things to assist. And something you should also be aware of, different states have different. 99% of the contracts will be the same, but there will be a few state-specific provisions, such as South Carolina. There's a tax compliance certificate you need when you close, so you don't take on any tax responsibility as a buyer and things like that. So there are little things that make a difference depending on the jurisdiction. There's a lot of big things in the contracts that you want to make sure you have an experienced multifamily or apartment attorney who's used to closing those, because there are things that they know to look for that your general, even if it's a 100-person law firm, but if they don't, a large law firm, but if they don't do multifamily regularly, they know how to close a commercial box, but they don't know the ins and outs of the multifamily business and what you really need and what your issues are often in these closings. So our firm, you can Google us under Brownlee, Whitlow, and Praet and find us. You can email us at realestate@B as in boy, W as in Wilbur, P as in Peter, F as in Frank, -law.com. And be happy.
We got
somebody just put up our website on there.
Perfect.
And we're in the process of rebranding and redoing our website now, but the one we have there is fairly decent and all the contact information is correct.
Wonderful.
So I appreciate that, Danny. I'd like to thank you all for having us on today. We enjoy working with you. You're a very knowledgeable group that we work with and make our lives easier as the attorneys, which makes your lives easier and a little bit less expensive as being sophisticated like that also. But we always enjoy working with you, and we're happy to be on and support the multifamily investor nation too. We think it's a great resource for people out there.
Wonderful. Well, that is it from us for today's webinar. Go ahead and sign up for next week's webinar. Melissa will have the info up shortly for next week, Tuesday, same time, same location, all virtual. So we'll look forward to seeing y'all next week. And again, Norm, thank you so much. We really appreciate getting the educational information from you today. With that, I hope everyone has a great and wonderful rest of the week, and we'll see you next week.